Lindsay's no longer. Yeah.
Well, it's interesting. Notice the appearance of
Yeah.
everything.
Yeah. Yeah. She's going to the state, but I think we have two.
Likewise.
Yes. All rise. The District Court of Appeal of the State of Florida and in for the Second District is now in session. The Honorable Craig C. Valenti, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. You may be seated.
All right, good morning, folks. Welcome to the session of the Second District Court of Appeal. As you know, everybody has been here before. There's 20 minutes per side. Napoli, the appellant rather, has the right to make a brief rebuttal argument, not to see 5 minutes after we what's going. Okay, so those move in mind, is the appellant ready? All right.
Morning, Your Honor. My name is Paul Griffin, Catholic. Pastor County and for the State Condition Circuit, effectively after filing the done. There is one issue in this whether the trial court committed fundamental error when the court considered unsubstantiated acts during the sentence. Specifically in this case, the trial judge was provided aided to uncharged misconduct, which occurred the day that the leading scene was. That police report was entered into evidence. The trial judge questioned the prosecutor about it.
And the trial court did do some questioning before sentencing, but what in the sentencing are we to look at to see that the trial judge did indeed rely and consider the uncharged act in sentencing?
Specifically, Judge Smith on page 215 in the record, the trial judge tells Mr. Irish, but there's times in your life of all things that are going on in your life, you're selling drugs, you're hanging around drug dealers, they're shooting up the car, they're shooting up the house, they're throwing the gun, and we're living a bad life. I'm glad to know you termed it that statement. So,
Okay, so that's anything other than that statement.
other than that statement, the trial judge of the police report, placing the police report in evidence, specifically confirming it was prosecutor, Mr. Irish had disposed of the firearm that morning, and it was in residence. Got up that morning for located in the residence, which was not on this person. And again, he and his fault were victims of that shooting.
Of course, the sentence that was given was 15 years, right?
It was.
Well within the parameters of the legal sentence.
That's right.
It could have been as much as 30 years.
It could have been as much as 30 years. And while the courts of the state have said it's not an appealable issue to appeal a sentence as well within the statutory guidelines, range. There's exception that this court has recognized on numerous occasions when the trial court relies on unsubstantiated allegations of wrongdoing and imposing sentence, which I submit the court did here.
So what's the remedy you see?
The remedy I seek is a new sentencing.
At the new sentencing hearing, what's the maximum sentence your client could receive?
That's a complicated issue, Judge.
Not that complicated.
I would submit that 15 years based on double jeopardy principle should be the max. Or that it could be.
Is there a specific? You don't argue that in this appeal, so it's kind of irrelevant.
Correct.
The new trial judge has got me right, to have to figure that out. It depends on what might be moved. If you gave him a 14-year sentence, we're moved. I always thought, personally, I'm not doing research for you. I always thought the sky's the limit. Statutory max is the limit on remand. And if you have a client that believes the max is 15, gets 25 or 30, you got a problem. Someone does.
Better feeling confidence, as I understand the court's position.
But seems like a bad deal for what happened.
Doesn't the case law support that it's an entire review sentencing hearing that it isn't canon?
The novel proceeding.
The question of whether it is a no proceeding or not is a complicated issue. It depends who the new judge is, depends on the evidence presented. It relies on the whole code. I don't think this is.
We can turn it to the first.
I hope I understand the course of reasoning. In this set of circumstances, I would submit based on the case law, I would not, I would say that 15 years is the maximum. Even above that.
Well, you're asking for a different judge. A different judge might have a different view of the evidence. New facts might come out. That's why they don't find the judge's hands to the original sentence. We don't know what's going to happen. Okay. Anything else?
Yes, Your Honor. Specifically in this case, the trial, it's not a situation, there's a whole litany of case law that describes how a judge, there's an isolated mention of unsubstantiated misconduct, since the judge makes some specific statements or makes some specific arguments that does not encompass that in the opposing sentence, being disharmless. I submit that is absolutely. In this particular case, the trial judge heard about unsubstantiated conduct. He had a police report that was discovered to the defense counsel the day before the hearing. He specifically questioned the prosecutor on it. He referenced it during the sentencing. I would submit to this court that she relied upon unsubstantiated allegations of conduct. This court and numerous other district courts appeal and found to be fundamental error. I respectfully ask that the court reverse and demand the sentencing either before the same judge.
Thank you very much. You get your 5 minutes.
Yes.
I apologize for not being able to hear everything you just said.
Sonia Lawson from the Attorney General's office, on behalf of the state.
Yes. Even better. Thank you very much. Welcome.
First, I'd like to address Smith, specifically asking what did this court point to demonstrate rather than rely on what is pointing to is statement that the judge read. I want to, I think it's worth us going through the statement because the first part of the statement is not regarding misconduct. The first part of the statement is charge conduct. Just 3 or 4 months before the incident, it was charged with possession of drugs, selling drugs.
But it occurs immediately following the sentencing. And it gives an explanation, basically, why the court did what it did. And so I think there's a little, I know where the council pointed to this part, because that was my specific question, was during sentencing. But there's other problems that I see in the record where to tie it in. You have the trial judge, sentencing judge involved in summarizing some of the facts with when the state relates the uncharged conduct. So you have a number of the court statements, and it's not just an isolated statement, it's a number of different statements throughout the record. And then you have the sentencing judge at the very end tie in the uncharged. I think with maybe just one, maybe at the beginning, maybe just one at the end, but when you have it both on both ends during the whole phase of sentencing, I think this really rises to the level of where the trial court was considering this uncharged conduct. So that's what I'm looking at, that this was fundamental error, and I know you disagree, but maybe you can help me consider with the state how we cannot consider it to be the trial court considering that uncharged conduct.
Well, again, and I think it's the word consider is being used loosely. Because when a court considers this conduct, when the court hears that information, it's inevitably considering it. It's inextricably entwined. So we really have to point to in the record how the court actually denied or even weight. And in this case, there really wasn't anything to point to demonstrate that the court gave the weight. Now, even during the sentencing, when defense counsel raised that it was going to seek youthful offender sentencing, the trial court specifically said, and that's at page 176 or something, specifically said, we're going to wait to the end and we will address that. So if this wasn't a situation like you have where the love case was a couple of years ago, that was on the circuit, where this misconduct was a feature of the case. In the love case, there's a situation where there were 4 or 5 witnesses that were called and gave testimony about uncharged misconduct. That didn't happen here. There was no evidence that was presented to the court regarding discharged conduct. At the end of the sentencing hearing, the attorneys for the parties discussed the uncharged conduct, but the attorneys on witnesses, there wasn't evidence that was actually presented. And I think this whole issue got conflated where after all the witnesses testified, and the defendant came up, the defense counsel said, you're going to be seeking the youthful offender status, and gave all this information indicating that he was going to turn his life around, he was remorseful, he was a candidate for rehabilitation. And it wasn't until the rebuttal that the state and
Use uncharged conduct to rebut that.
and the judge's inquiry with respect to that information was really clarifying questions. There was something that came up in the case of the hearing where the judge noted that the address that was given for the police inquiry was different than the address where the motorcycle was hit and these other issues came up.
You would agree this isn't a case like the Mikado versus State, where there was actually no inkling, what the opinion wrote, no inkling that the trial court even considered any of that evidence or conduct that came in, because we have here a discussion after sentencing explaining, the trial court explaining why the sentence was given. And we have the uncharged conduct in the middle of that. So it's not like we don't have anything.
I do think Ricardo is instructive, and I think that we need to remind you. The judge's explanation for the sentencing, the judge specifically says that the reason the 15-year sentence was imposed was because of what the defendant did that day. Excessive speed, propelling the 7-year-old over 16 yards, killing the 7-year-old, leaving the scene and not looking back. The judge is very explicit in giving an explanation as to why the sentence was imposed. And I think where the judge comes back and asks questions about the misconduct, the information that was provided, I think those were clarifying questions. I think the judge hearing that information and processing it. When you look at what the judge actually said in this ruling, there's no reference whatsoever to the misconduct. And I think that's what's important.
Well,
And that's-
since you're throwing the gun in you were living a bad life. Isn't the uncharged conduct the facts about the gun?
Well, I think you have to read that
Yes or
entire
no? Yes
statement.
or no? Isn't the uncharged conduct the incident with the gun?
Oh, yes, that's part of it. Yes, it is. Now, I think what's important in that statement is that the judge basically said, I heard what you had to say, heard what you had to say, defense. And at the end of that, the judge says, but that doesn't stop the ramifications of what you did. You have to, and I think the family said it, there's consequences for your actions. That's at page 214 and 215 in the record. So I think the court was basically, I've heard everything you had to say, but let's get back to the facts of this case. You were driving 63 miles an hour in a 30-mile-an-hour zone. You propelled a 7-year-old 16 yards, killed that 7-year-old, and you left the scene. And I think that in the ruling, the court is explicit in pounding those facts, not the uncharged misconduct. And I think that this court addressed that also in the Ricardo case, that you have situations where in the trial court is presented with all kinds of information. And in these sentencing hearings.
Well, there's a PSI file, correct?
Yes,
There's all kind of stuff in the PSI
yes,
that might be considered hearsay or not admissible.
sure.
So and that came in without objection, correct?
It did come in with, it did come in without
So
objection.
we don't know what the judge considered in the PSI and what the judge said. I read the PSI, well, you really a bad person. You don't know what the judge considered in sentencing, except the judge did specifically say, this is what you get for what you did that night.
Correct,
End of story.
correct.
So I can understand what the other side is saying. You can't unring the bell because the judge did hear a lot of improper things. There's a burden on the judge to then say, and by the way, all these improper things I heard, I'm not considering, or the fact that he said, this is what you get for what you did that night, that automatically excludes those improper things from consideration of sentence.
Well, I'm glad you asked that question because the Supreme Court addressed that in Garcia. In the Garcia opinion, you had a situation where, the document was well contemporaneous objection. And the court did not explicitly say in Garcia what it relied on within its ruling. But in Garcia, in that case, what the court did do, the court, I'm sorry for getting
That's okay.
my cases confused. I believe that was, just give me just one.
No, take your time. I'm gonna mention one thing.
Okay.
If it's a totality of everything that happened, then we get to decide, which is not to say something that correctness was not overcome.
Yes, that would have to be the analysis where there are any explicit statements. But in this case, there's an explicit statement indicating that the court relied on what occurred that night. If you were looking at a situation there weren't explicit statements, you could look at the entire record. Love is the case, where the example of what you gave before about parting out, say that I relied on a piece and didn't rely on another piece. Love is actually that. Love is the case where the court specifically said there are two pieces of misconduct that we're not going to rely on. Hearsay, another piece. But it didn't say that it was going to rely on the other misconduct, but there were like 4 or 5 witnesses that testified with respect to the misconduct, and it was a feature of the case. And the court said, in looking at the totality of the record, they couldn't have said that the court didn't rely on the uncharged misconduct. So that was the case. If there are any other questions, Your Honor, we will rely on our.
All right, well, you got 5 minutes. Fine.
Yes, right. Respectfully disagree with those as it relates to the trial court relying on uncharged misconduct. In this particular case, there is evidence that the trial court did. Specifically, she was asking questions about the police report itself. The police report was admitted into evidence. The police report references marijuana, which the court noted. The police report references disposing of a firearm. So there is evidence that the trial court did rely upon unsubstantiated allegations. And what the law says when this happens, the record reflects the trial judge may have relied upon permissible considerations in the opposing sentence. The state bears the burden to show from the record as a whole the judge did not rely on those considerations.
You don't think that sentence is enough? You don't think the sentence that we both quoted is enough? You're being punished for what you did that night?
I think if the entire record is read in context with all the statements the court made as well as the question of the prosecutor, in addition to the specific statement that was made in an opposing sentence.
Well, is the standard review abuse of discretion or de novo in a case like this? You're arguing fundamental error, right?
I did, Your Honor. Was a situation. This circuit, as well as the other district courts in the say that it is fundamental error and a due process violation. There are 1 section 9 of the Constitution unsubstantiated allegations in this context. In terms of the standard review, in August of 2022, the Florida Supreme Court came out with Garcia, which says really it's objected to. Fortunately, was Mr. The case of was required to review it for fundamental error. I would respectfully submit that Mr. Ditch case based on the police side, fundamental error did occur in this case. It was a violation of the right. Respectfully asked, there is support for the man. Wants to deal with the questions that are needed.
Thank you, folks. Thank you both. Have a great day. Next case, we'll talk to you. Yeah, round to back now. Good.
You can go away for 1 second, Your Honor. Sorry.
Well, stuff going on there, huh?
Other materials. Good morning, may it please the court. My name is indulgence. There's no 5 minutes rebuttal. Court should reverse and remand in this single progeny case for at least 3 reasons. First, trial court erred in instructing the jury in both phase 1 and in phase 2. Use the damages. Second, the trial court erred in permitting plaintiff's expert, Dr. Stowaway, to give highly speculative testimony without examination, and to do so for the sole purpose of disparaging. And then third, the trial court erred in preventing Reynolds from cross-examining expert things, concerning his reliance worksheet containing falsehoods, and then instructing the jury in a way that again disparaged Reynolds. And to start with the issue of punitive damages. During both phase 1 and phase 2, bifurcated trial, the trial court told the jury that they could impose punitive damages based on quote misconduct. Reynolds couldn't. We have cited cases from around the country, recognizing it is impermissible to impose punitive damages on the kind of co-conspirators, folks on its own conduct. Friend has not grappled with those, they're out there. The court doesn't have to look outside of Florida. We have the Alexander case. So Alexander was an annual progeny case. The defendant is held liable for conspiracy. And then the defendant argued on appeal, the award against it was impermissibly based on conspirators. And the 3rd district rejected that, applying settled rule that you
The Laureate case.
exactly. More largely Alexander. And the 3rd district rejected that argument. It noted that the trial court, keeping with the widespread rule, had instructed the jury they could only impose punitive damages for harm that the defendant caused and defendant's own conduct. And so the case fundamentally rests on that rule. My friend has an alternative view. It's based on reading the opinion selectively and out of context. And so the key point about the opinion is it proceeds in 2 parts. First, you have that instructional. It's setting out the legal. And then you have a lengthy discussion of the evidence. So what the court is saying is that working within the proper legal framework, the evidence supported, the evidence of Boulevard's own misconduct supported the punitive award that was given in that case.
Well, the jury instructions were approved by both sides, right?
In this case?
Yeah.
No, we had a dispute about this. So Reynolds,
It was ultimately given over your objection.
yes, it was given over our objection. Absolutely. And my friend has, aside from the 2 issues of argument, there has been no claim of waiver. And I'll get to the 2 issues in a minute. But Reynolds put forward an instruction that said, affirmatively, you have to look at the defendant's misconduct. So ask whether the defendant's misconduct met the expert. And my friend proposed an instruction that said, ask whether the defendant's misconduct or the misconduct of co-conspirators met requirement expertise. The trial court ultimately landed on my friend's version over our objection, with the addition of the language in the further. So you wound up with an instruction.
Well, the conspiracy is the equal to shooting the independent toward another.
That is true.
And that's what the judge was going by. That's what the pivotal key, the instruction.
That is correct. We're not disputing the general rule of conspiracy liability. Our point is that the punitive damages is part of it. That they, both as a matter of case law and precedent, also as a matter of
We have to have
policy.
some sort of compensatory before you get to trial and punitives, correct?
That's certainly true, Your Honor. That's certainly true. And we're not fighting. My friend has many cases about vicarious liability for damages with conspiracy. That's not the dispute. The dispute is just about punitive damages. All those cases we're citing, including like the Laughlin case or the Berlin case at the federal system, are saying, look, punitive damages are. And Alexander applied that widespread rule, and it focused throughout on Warlord's own conduct. And I think the closing quote, I mean, it mentioned Warlord 25 times in the relevant part of the opinion. by name. It makes them the key actor in every bit of
Did
conduct.
the verdict form differentiate which count was awarded?
In our case?
Yeah.
It did not, and that's a true issue.
Isn't that problematic for your argument?
Absolutely not, Your Honor. So there's three reasons the true issue will. One is that it has been obviated by special standards. The Supreme Court adopted the special promissory standard, no law that the true issue rule does not apply. And it's the reason is that the burdens are different. So special assumes that an error is harmful. And so it falls on the beneficiary of the error to show that there's no reason, possibility that it contributed further. The true issue rule presumes that errors are harmless unless you break them out of the verdict form and show that they in fact did the work in the ultimate verdict. And so they rest on fundamentally different premises, and the true issue will therefore be there. But the court doesn't need to reach that.
Okay, let me go back and I have a question on the verdict form. And I know you had said that there was preservation as far as the conspiracy language in the jury instruction. Was there any objection to the verdict form?
No, so the verdict form did not break out the claims. We did not fight the verdict form. It's issue for.
Okay, I just wanted to know if there was an objection to it not being broken out.
No, there was not. But that's true issue rule just doesn't apply here for the reason I've already given. But also because this court's recent decision in Quicken. We submitted this as a second supplemental authority. And this court said, and I'm paraphrasing, but it's a close paraphrase. True issue rule does not apply the issue of punitive damages. And so that is a very recent decision from this court recognizing it. I'll add the third reason the true issue rule doesn't apply is because that holding is compelled by first principle. So the Supreme Court has said that the true issue rule is just not going to apply. So the Grits v. Tomlin case held that you're not going to apply the rule if the issue is an error with respect to one element claim. And in the Avenado case, when here, the court held that the true issue rule does not apply when the error on that theory and then the other things that could have supported the award have different measures of damages. And so that's what this court was doing and doing. And the reason is this: if you make an error with respect to the quantum and type, what conduct you were doing the punitive analysis for, you are fundamentally changing the measure of damages because you're changing what's being punished and deterred. And that's why this court gets straight to special enjoyment, because like in Avenado, the error in question changed the theoretical thing that the payment is based on. And so the court should reach the merits of the issue. I've explained Alexander as something. I will add that the traditional widespread rule in all the cases we've cited makes sense as a policy matter for two reasons. One, there is just the fact that punitive damages under both federal and Florida law are limited to only two things: punishment and deterrence. And as the Ross case out of the Louisiana Supreme Court made clear, that is a highly individualized inquiry that requires you to look at not. And then two, the U.S. Supreme Court has said you need safeguards that may result in arbitrary and punishment. In that in the instructional context, in that substantively, and certainly imposing punitive damages based on co-conspirator misconduct creates both of those risks. You add in co-conspirator misconduct, you're creating the possibility of a very large award, and more to the point, in cases like State Farm and Campbell, we're creating the risk of overlapping. Why? Because every single member of that conspiracy could be held liable for punitive damages for everybody else. So everybody's being double taken. And so that would violate overlapping punishments. That just underscores why the traditional makes a lot of sense. I'll note that my friend has cited no cases contrary.
Does it make any difference that in Deacon that their verdict form listed the separate amount for punitive damages?
You talking about Wigman? I'm sorry, I was making sure.
Wigman.
Okay, I wasn't trying to correct. I just want to make sure I was addressing this. No, because that only was with respect. Punitives are always treated as give them entitlement questions separated out. And then in these single cases, these complicated cases, you then go to phase 2, in which you get one lump sum of punitive damages. I've never seen it. So again, the merits are before the board. My friend has cited no precedent contrary, should reach the merits. I will address briefly the harmless error argument my friend has put forward. My friend doesn't address the governing standard. It's special and it's doxable when this court says special applies to instructional error. And what that means is the beneficiary of the error, the plaintiff in this case, has to show there is no reasonable possibility of error. That showing can't possibly be made here, one of which is just common sense. You've got a case chock full, as my friend's appellate brief makes clear, of evidence of co-conspirator conduct. You've told the jury that they should consider that evidence and award punitive damages. Certainly, there's a reasonable possibility that they then take that patients. And then 2, the extent the court had any doubts about that, there's actually a presumption juries follow their instructions. And so it stands to reason that a jury pulled to consider co-conspirator misconduct. I do want to speak briefly to the second and third issue we raised. I want to flag very quickly that they should be considered together because they have a multiplier. This relates to Dr. Soloway, Cummings, and the problem is that a theme was created at trial that Reynolds counsel, based on these errors, was disingenuous, misrepresenting that.
Getting back to 60,000.
But that's one of them, and Dr. Cummings is the other.
They raised $60,000. The Reynolds statement.
It wasn't Reynolds opening
They
statement.
could have been objected to, but it wasn't. Now you complain that taken out of context, taken too far, use of nefarious conduct.
Yes, but I would add, subsequently, there was no nefarious conduct. So we received medical records that were available. And Reynolds counsel said as one, and I'm quoting, example, in quotes, and then quote, of what the evidence of damages in this case would show was the $60,000 in medical expenses. That was a comment on what the evidence would show. That is what opening statements. And so,
But then it was raised again by Reynolds in their closing statement.
so at that
Well,
point,
they led with the 60, they ended with the 60, and they complained about the 60.
they did not end with a 60, Your Honor. They ended with a statement about a stipulation of 2,000.
Where did that number come from?
We got a stipulation sort of mid-trial after the Dr. Soloway event went down. That was when we would review the procedure. But that can't paper over the error here for a
Then they
error.
waived the claim for person.
They did, but to the extent the concern there is harmlessness, the harm is not limited to the claim of reimbursement. It's disparagement of counsel.
So here's my question. Ugly as in the eye of the beholder. Doesn't seem like the trial judge put this as ugly. Took it in stride, it was kind of irrelevant. Who cares if the medical bills will? And everybody knows it's more than 60,000 for this procedure anyway. Didn't seem like they directed their anger and animosity, misunderstanding towards the counsel.
Your Honor, frankly, this was an abuse of discretion. There's no way to read this record, but that it was disparagement of counsel. And the plaintiff said that's what he did. He said it was to show that what Reynolds said was not even possible. I'll add about the stipulation. Apparently, they can only get agreement for 14,000. Dr. Soloway's testimony was that the total medical care would be many, many more than 60,000. And so even that meager stipulation, in a purely formal sense, could not cover the harm that was caused.
What was the time period that these bills?
I can say it was many years. He got it.
But most people don't have their bills over many, many years. So that would have been a problem, which burns on them. So that's probably why they abandoned the claim.
Your Honor, respectively, no. They kept that claim in the case until Dr. Soloway gave his testimony and then promptly outside of the court withdrew it. So this wasn't some like assessment that we decided we don't want to press this claim because it ruins our case. This was keeping the claim in the case and have a court conspiracy to counsel and then withdrawing it by emailing counsel outside of court. And so that heightens the disparagement, lesser disparagement in Florida civil.
Was the curative instruction thought?
No, Your Honor, by the time the disparagement became clear, the ship had already sailed. And so we got the stipulation to kind of try to make lemonade out of lemons, frankly, unsuccessful. Everybody knows by the time we back for the I would add that Dr. Cummings, very briefly, Reynolds should have been allowed to cross-examine him with his reliance on the worksheets. I won't belabor that point unless the court has questions other than the point the state wanted.
You're down to 5 minutes, by the way. So
I understand, Your Honor.
keep going.
I will very, very briefly. So I don't belabor that point other than the point the state wanted and say we should have been entitled to a full inquiry. I do want to add that the court's instruction telling the jury that Reynolds had acted quote, totally improperly in acting about the worksheet, and that Reynolds' statement was unsupported by the evidence was doubly erroneous. It was not only an improper comment on the evidence, because the evidence did support the idea that he, Mr. Bukowski, had an advantage of litigation. Because not only did he submit under penalty of perjury his last report, that's common sense, he thought he would gain. He actually had a claim for lost wages that he went under entertaining, and that's in this amended worksheet. And so that confirms that the type of thing this was relevant to was in the case of the kind of total lies. And more to the point, these are the kind of lies that make it. So in closing, I will add that not only was it improper comment, it was again disparaging. In Simmons, which we started in our brief, and in Seaboard Coastline, lesser disparagement required a new trial. Certainly in this case, we would have the two disparagements together and we consider together both in prejudicial error analysis and in as independent errors, a new trial.
Just so that I'm clear, the amended worksheet has his misstatements about his education.
No, not the amended worksheets he was withdrawing.
Okay, the amended worksheet, wages.
And the first worksheet said undetermined. He was clearly entertaining the idea of a lost wages.
But when he submitted the second, which was amended, it had lost wages, but it had the correct history.
That is correct, Your Honor. During the first one, when he told the lies, he was still undecided. I will remember.
You got a little, I'll just say 3 minutes.
Thank you, Your Honor.
And yes, my name is Celine Humphreys. I represent the athletes. Most of the argument that you just heard was directed to community damage insurance. We did cite Alexander. Alexander does not support the defense. Specifically, Alexander was a different issue. Alexander, that case, the appellate court had the first fraud for the underlying cause. So the argument on appeal that the court was considering is whether or not the evidence that occurred. Keep in mind, fraud is fraudulent concealment, but it's also the conspiracy to commit fraudulent concealment. So the issue that the third district was addressing was not what is a proper jury instruction. It was this concern that the punitive damages of the jury was improperly affected by consideration of evidence that related to one of the two fraud counts. So the two cases, this case and Alexander, go hand in hand, and that they're both talking about the legal issue of what may a jury consider when determining punitive damages. Alexander does not address what the proper jury instructions. I say that to give context to. So when the court is looking at R.J. Reynolds, excuse me, it was not R.J. Reynolds, the defendants are regarding whether or not a jury may consider the conduct of co-conspirators and determining whether to award punitives and how much, the court said no, and it said so for two reasons. The first one was simply a practical. In that case, that judge, based on jury instructions proposed by those parties, including the plaintiff, I don't know. There, the jury was instructed only to consider the conduct of the defendant. So to the extent that the Alexander decision cites a jury instruction differently, as it is not a holding as to what is a viable or permissible jury instruction, simply the practical of why the defendants are being failed. But the bulk of the decision addressed the legal issue. The bulk of the decision said, and you're wrong, because here, because we have conspiracy counts, conspiracy to commit fraud, because this jury hears of the acts of other defendants, deciding that underlying cause of action, that same evidence may be considered side of punitive damages. It says so on 2 pages, 79, 81, both of which I believe. So that's Florida's precedent that is spoken on the issue. I've also provided this court with other laws supporting our position. First is vote right. Vote right is a case I handled at this court, and the decision issued by Judge Silverman came affirming a verdict against one of these cigarette companies when the only cause of action that cigarette company was found liable for was conspiracy. So in that case, there was a defendant that was not held liable for negligence, which is direct conduct, not held liable for strict liability, which is direct conduct, and not held liable for fraud. The only basis for that one cigarette company to be liable was on a conspiracy count. And this court rejected the corresponding request to invalidate punitive damages. So although not the square legal issue that you're hearing today, this court has acknowledged this circumstance. And I also provided you with many decisions in the Emo litigation. So that's one thing that's interesting about the Emo possible litigation. In many respects, these are the same cases being argued over in the trial courts and on appeal. The differences relate to whether or not a particular person was addicted, how many years they smoked, what disease they had, but the legal issues otherwise not tied to a person repeat over and over. And so in the Emo litigation, you have in the many decisions that are reviewing whether or not a punitive award is excessive, when the courts have found that a punitive award is not excessive, they summarize the evidence, they summarize the evidence. It's consistently. And then you also have the fact that some courts have already considered this issue. I was only able to find 2. RJR is a party in most of these bills and works with the other defendants. They would know more, but I did find Lambert. To you on this very issue, very argument presented to this court. And it was unsuccessful there. Also unsuccessful in the first district court of appeal. And so, for all of those reasons, their argument just going right to the merits, I think want to mention this because I can't resist it. The argument about the standard jury instructions. Standard jury instructions are not written to cover every single circumstance. Standard jury instructions are to cover the more typical circumstance so parties can use them more readily. And then parties are under an obligation to change the standards when required by the facts. We're very fortunate that civil conspiracy is not common. So the fact that the standard jury instruction doesn't include civil conspiracy and co-conspirators is of no moment in this litigation. And another way of saying that is, if you look at the jury instruction given here, there's actually 2 other groups that RJR was held, that the jury was told to look to. It was told to look to, obviously, RJR's conduct, the co-conspirators, but also RJR's predecessors. It's not in the standards either, and RJR didn't object to it. And that leads to one final point. This is one of those notions that's, I won't say it's moot, but at this point, at the point of the trial, all of the conspirators that are talked about in the Emo decision, many of them, RJR has purchased. They come under the predecessor. So only company left now is Morse. Also, really what the jury heard about and hearing about co-conspirators was the fact of these industry organizations that were created by RJR. And it's now companies that are owned and built Morse. And the evidence about that is that RJR, and RJR was the most involved, one of the most involved in all of this, or the most involved, had its own corporate officers running those. So for all of these reasons, there's a practical reason as well why this is done. I heard your questions on the medical expenses issue and on Dr. Cummings. Those are the 2 evidentiary arguments that I in detail in my brief, point by point, explain why those arguments fail, separating them out, and explaining that essentially all of the arguments are waived. Is there anything in particular on those abuse of discretion issues that the court would like me to address?
They raised the issue, and I thought they closed with it, but he said they didn't close with it. They highlighted an issue, they complained that the issue was teaching crime.
Yes.
Accuse them of various conduct. And my comment was that the record could be read possibly either way. But if it can be read one way that helps the appeal, one way that doesn't, you favor, the one that favors the trial.
Right, because the standard of abuse of discretion is the judge Vargas do something that's arbitrary, fanciful, another.
It's arbitrary, and that would be the argument.
That would be their argument. So I'll take a few moments to address that. Really, when you break out this issue, there's three different points. First is the question of relevance, and that's what RJ argued.
And that could have been objected to by plaintiff's counsel at the very beginning. Because you don't normally bring up evidence that you don't intend on showing, but you assume the plaintiff's going to show their case in chief and then object to it when it comes in.
Well, one thing you'll notice in this record, when you read the whole record, plaintiffs did not object very much. And so our approach is to basically object if we're responsible. We don't want, we want to
It's a
reduce.
different thing.
Yeah, right, and professionalism, and we also want to reduce the opportunities for appellate issues. And so we, to call it sports term, we play a defense game. And so the fact that we didn't object at that moment didn't mean that we agreed with it. And then what we realized as we thought about it is how they said it. They did not express it as a medical expense issue. Think of all the court action where parties are fussing over medical expenses. You're going to hear stuff like that treatment wasn't necessary, that charge was irrelevant.
Well, they said that that's a substantial amount of money.
And you know what? That ties to something completely different. And that's the case law gave the court, that it is very permissible for parties to argue to a jury what the pain and suffering should be based on how much medical treatment was received. And so defendants can and do say, medical bills were only X amount, the pain and suffering, this crazy amounts of plaintiffs for was asked for. That is the type of argument. That is the comment. Never at any time in this opening comment or in closing did they climb in to address a medical expenses claim. This isn't the kind of comment that would pertain to them. And so what we realized at first, we're like, well, if he hardly said anything, he's really not addressing medical expenses. And then we realized, oh my gosh, this ties into pain and suffering. He said the word substantial because pain and suffering that we were referring to at Ireland when we used the word substantial. Remember, this opening comment specifically took the jury back and said, ladies and gentlemen, you remember plaintiff's counsel on Waudire talking about substantial damages, and then defense counsel connected that to medical expenses. So we realized we have to address the number because we're only questioning pain and suffering. We can't let this jury think that it was 27 years, 27 years of medical care involving many surgeries, significant hospitalization, infections, and complications cost only $60,000.
So, next you said Dr. Soloway, is that
Yes, sir.
all really good?
Oh, no. That is what we focus on, and I probably left you that president brief. Dr. Soloway was an expert called to explain to the jury all of the harm that had befallen us with the bladder, all the surgery. It is not for this issue, it is to explain the treatment. No, he was asked very little about the cost, so let me say that better. He was already a witness, he had already been deposed on the fact that he was going to explain and tell the jury, because Mr. Murkowski had smoked for so many years, he contracted bladder cancer, and this is the treatment and experience this man has had for all of his time. So when we then turned to the jury and talked to pain and suffering, we based that on the past experience of those 27 years, part of which had been described medically by Dr. Soloway. Because he was already scheduled to present this expert opinion, and that's what he was disclosed with. We then asked him this one point, and the questions were extremely truncated. Don't even cover 2 pages of the trial transcript. And it was simply based on your review of your experience, based on your background, you're a logic oncologist for 50 years, based on your understanding of the kind of treatment and hospitals and billing in that 50-year experience, and based on your knowledge of this man's history that you had to know to give all this other testimony he gave us, can you tell us would 27 years of medical care cost $60,000? And his answer was no. It would have been many, many, many times. That's it. That's all we asked. And we never repeated it again. We never mentioned this to the jury, even when the defense pointedly used a stipulation against us in closing. And use that stipulation, first of all, telling the jury about out-of-court conversations, suggesting to the jury that we had conceded error, challenging us and accusing us asking Dr. Throwaway these questions improperly. We still stayed quiet. So the only thing on our side that we did was page and a half into that, and that's including objections. The actual testimony was this. That's all we did. We never even once in the whole trial mentioned medical expenses. And then I'll go ahead and go to the assumption. Their assumption that the second point is that all of this was to denigrate. So that is based on 3 flawed assumptions. The first flawed assumption is the only reason we would have talked about any of this is if we had a medical expenses. That's wrong for the reasons I just said. This kind of testimony is also relevant when arguing in suffering. I provided the court many decisions where medical expenses evidence are admitted in cases where there is no medical expense claim because juries can look to the amount of the bills and trying to figure out what to assess as human suffering. So that assumption is wrong. The other assumption is implicitly, anytime a plaintiff responds to an allegation or statement by the defense, it must be attempted. But if a defendant is going to take on the position of making a factual representation, there's nothing wrong, even in criminal cases, with the plaintiff or the state responding to the factual assertion. So that assumption underpinning this notion that we were denigrating them on the case. And then the third assumption is based solely, and this is really the only thing they can point to, is the fact that we abandoned our claim for medical expenses. And as they state, I'm the one who abandoned that. I was out of court with their appellate counsel out of court. We're constantly emailing back and forth about jury instructions. What are we doing or not? And trying to resolve as many things as possible before 2 of us, not the trial lawyers, get to court to talk about the jury instruction. And I told them we were not pursuing the medical expenses. Parties abandon claims all the time. All the time. And Engle plaintiffs almost never pursue medical expenses. So for them, for that one act to assume that this was some sort of intentional attempt to denigrate them in front of counsel, it fails. It's also illogical. So consider what their argument actually is. Their argument is, well, if you hadn't pled a medical expenses claim, we wouldn't have misrepresented at all. Whether we had a claim or not is irrelevant to the fact that they told the jury in very clear terms, ladies and gentlemen, the bills here are only $60,000, or they said about almost $60,000. And in all of this discussion for Judge Vargas, they never disagreed that the overwhelming majority of medical bills were not available. They knew that. So it's illogical and it's unfounded. And there is, and frankly, when you are going back to the standard of review, you are reviewing whether Judge Vargas used his discretion, and the only argument is based on inferences. Inferences are almost never successful in such a standard. So the only other issue is the one regarding Dr. Cummings. You didn't ask that many questions, and there wasn't much comment. Would the court like me to address the issue of possibilities? I really appreciate your time. Thank you very much.
Right, so round it up to 3 minutes.
A few points. My friend suggested that Alexander didn't address this legal issue. I did address the legal rule. You don't spend 9 paragraphs applying a legal rule that you were just accepting for the sake of argument, which is what this court did in Alexander. And the fact that it wasn't an instruction case is irrelevant because instructions are based on legal rules that are applied in cases. Alexander was developing and applying a legal rule. My friend mentioned vote rights. At R 79232, our friend acknowledged that vote right was not on point. And then to run down her cases, and every one of them, it stands at most for the idea that punitive damages can be based on a conspiracy claim. That is something we are not disputing. And most of them actually say expressly that they're looking at, quote, the defendant's own conduct. And that's in the Caton case of DCA 4 and the Burt case under the Pennsylvania Superior Court that my friend cited. My friend mentions the Bush case and the Lambert case. I was surprised to hear that. Those are PCAs. I would just respectfully refer the court to the Schleswig case, which the 4th DCA said that it's improper to cite PCAs. The rule makes good sense. Both of those cases had waiver arguments that my friend raised, and so we have no idea what they stand. Anyway, my friend mentioned that there's only one co-conspirator left, Philip Morris, but plaintiffs in these cases leverage Philip Morris evidence a great deal. In this case, they emphasize a Philip Morris document referring to smokers as, quote, rats in a cage, in reference to like a Pavlovian response, and the idea of electric shocks on animals demonstrating the powerful urge to smoke. Internal Philip Morris document, nothing to do with Reynolds, and indicative of the broader kind of evidence, including ads of co-conspirator conduct that come in. As long as that evidence is in, the jury's told to consider co-conspirator conduct, there's a real possibility the error contributed to the verdict, and that's again the special standard my friend didn't confront. Finally, the pain and suffering idea that medical bills are related, I'll be very, very brief. We cited the Sublotny case that points out that that is a logical connection. You can imagine a very simple surgery, like setting a broken leg that avoids pain and suffering. You can imagine a very expensive surgery, like a cosmetic one. It does nothing.
Now to 19 seconds.
Thank you, Your Honor. Last point, the idea that that was relevant to pain and suffering. Probably the court can scan the sidebar transcript, and my friend never once suggested that this was a matter of pain and suffering damages. I see that I'm out of time unless
Good. Everyone, thank you very much. Thank you. Have a great day. Thank you very much. Keep going. Let's hit the Suncoast Transit case versus Moore.
May it please report. Counsel, my name is Jeffrey Jensen. I represent the appellant, Nelson Coast Transit Authority. In this case, the parties agreed that reversible error occurred. What is disagreed is what the court should do about it. Should the court agree that there was reversible error? And that issue is the issue of sovereign immunity. Nelson Coast Transit Authority is an independent special district of the state of Florida. And as a result, Iowa Florida Statute 768.28 subsection 6, pre-suit notice has to be served both on the Transit Authority and Department of Financial Affairs. In this case, the complainant alleged that they did so. The defendant specifically denied that allegation. In addition, but an affirmative defense that specifically stated that plaintiff failed to comply with the pre-suit notice provision of 768.28.
And you're complaining here on how the court dealt with the motion for directed verdict
Yes, Your Honor, but
by reopening the evidence?
by reopening the evidence, and then on top of that, both parties had requested a jury trial. There's nothing more sacred to our system of justice than a right to a jury trial. What the trial court did was conduct an impromptu bench trial. Heard testimony from heard testimony from witnesses, took in exhibits and evidence, but then never issued a ruling.
And would you agree with me that courts in dealing with the conditions proceeding on the pre-suit notice that encourage the parties to deal with this pre-trial motion before trial
That is the preferred method of doing so, but unlike.
Probably for the reason of what happened here.
But unlike, as that my colleague cited in her brief, 768.28 subsection 7, which requires that that be brought up pre-trial, that is not a requirement of subsection 6.
But are you disagreeing that the notice was given?
I'm not disagreeing that notice was given, but I'm disagreeing that I think the court should have directed a verdict for the authority, because plaintiff never listed a witness on a witness list for purposes of pre-suit notice, never listed any exhibits, and during the impromptu bench trial, never properly authenticated some of the documents.
Let me just hypothetically here, let's say, the court reserved on the DD, which or did in one of the rulings. And they're now on notice that they didn't do the pre-suit, so they're going to figure out how to try to get that evidence in, right? And you don't disagree that the notice wasn't given.
Don't disagree that notice wasn't given.
So how is this going to change anything? If the issue went to the jury?
If the issue had properly went to the jury, it was in the jury's discretion to determine, yes, you did this, or no, you didn't do it. Or if the court, as a matter of law, determined that they did meet that
And
burden.
I just don't see this as a gray area. I'm looking at the, exhibit, I think it's 23, and it's stamped received from the county attorney on, I think, September 21st or something like that. So I just don't see this as an issue that the jury would even be grappling with when they see that it's stamped received from the county attorney. So I don't know why we're wasting our time here on it. So why don't you make your other issue?
If I may address what you just raised, Nels Suncoast Transit Authority is not the county. The fact that the county received it, it was sent to the wrong agency. So that is not proof. They did not meet their burden of proof. And the jury.
But again, you're not disagreeing that your client did not receive it.
That's correct. I'm not disagreeing that my client received it. I don't know whether or not the Department of Financial Affairs received it, because that's not something that I have contact.
But we did have, I mean, in addition to the stamp receipt for the county attorney, and I appreciate your comment, we had the green cards, which were the return receipt.
Which were never properly authenticated.
Okay, I understand that. At the close of their evidence, until they reopen. Don't you really need to be arguing that there was some abuse of discretion for the court to reopen the evidence at that point in time?
I would argue that if the court had reopened the evidence, allowed all this evidence to be received in front of the jury, so the jury could make a determination. But the trial court had absolutely no authority to take that away from the jury. The only time you take something away from a jury is via a summary judgment before trial or to a directed verdict at the close of evidence. The trial court did neither. It had an impromptu bench trial in the middle of the jury trial, and then it never issued a ruling. And the jury was never given any information. Who was the true finder of fact for this issue was never given any evidence to support a ruling that they or a jury verdict that they did in fact comply with the statute. And I believe because of that failure to prove that, the trial court should have directed a verdict for Nels Suncoast Transit Authority on the pre-suit notice.
Mr. Jesse, did you want rebuttal?
2 minutes.
Got it.
Now, if the court determines that this case needs to be tried again, I just want to briefly touch on some issues. My colleague and I agree that the trial court erred when it determined that Dr. Bain didn't have an engineering degree.
Can I interrupt you for 1 second? When you said that both sides stipulated to error, didn't that stipulation include the remand for a new trial? What about an expert who didn't have a credential?
Both sides agree that Dr. Bain was qualified to issue the opinions he did, and it was error to keep out those opinions. I think that merits, I think the case law is clear that merits a new trial. If the court doesn't agree that it should be a directed verdict.
What's the other side view of that?
The other side's view of that is, in fact, that the trial court committed error when it determined Dr. Bain didn't have an engineering degree and was not qualified to opine in the area of biomechanics.
I think they do agree to a new trial, it's on the one expert on bona fide.
I don't think they raised, they didn't dispute anything, the contention regarding, Nicole Bonaparte. They simply said, yes, we agree the court made an error when it determined that Dr. Bain didn't have an engineering degree. He should have been permitted to testify. That was all it was said.
So you're saying the stipulation doesn't go the extra yard, doesn't explicitly say, and they get a new trial? How do you cure that mistake that they stipulate to if you don't give them a trial?
That's the only way to cure it is for a new trial. Now, the parties disagree on the aspect of the sovereign immunity.
Well, that's a separate issue.
Yeah, that's a separate issue.
Is that really right for this appeal that you get a new trial on the evidentiary matter?
Well, what this court should do is to first determine whether or not a mistake was made on the sovereign immunity issue and what the consequences of that mistake was. If the court decides that because they didn't meet their burden of proof, that it should be remanded to the trial court with directions to enter judgment in favor of the defendant on that issue, then there would be a need for a new trial. If the court determines that it's not necessary to go into the sovereign immunity, then the issue becomes the errors that were made during the trial. First of which was with Dr. Bain. Dr. Bain has an engineering degree, he has a medical degree, he is a certified accident reconstructionist, and he has.
And let me just read from the brief, from the answer brief, in the summary, the argument. Ms. Ford agreed that the matter should be reversed and remanded for a new trial. So they agree for a new trial, it's solely on the issue of.
Correct.
I don't think that you would said that.
If I misspoke, I apologize. We're in agreement with that. However, what wasn't said and what we do believe that we've met is we had a Daubert here, Dr. Bain, and I believe the evidence established not only that Dr. Bain is qualified, but his methodology met the Daubert standard. So if this case is remanded back, not only, I don't believe there would be a necessity to redo the Daubert hearing because I think all the evidence that was necessary to meet that burden was proffered during the Daubert hearing. Like with Ms. Bonaparte, the court never held an evidentiary hearing on Ms. Bonaparte because it didn't have time. What the court essentially did was told counsel for parties, hey, I'm giving you each 5 minutes to make your best arguments, and that's all you get. Never heard any evidence. And what the trial court did is it came out with, factual findings that were unsupported. So if this case is remanded, what we need to do respectfully is have a full Daubert hearing on the Bonaparte because that was never done. And as a result, her opinions regarding the market value of the medical treatment Lincoln had was never heard by the jury.
Did the court have at the Daubert hearing the deposition of Ms. Bonaparte?
I believe the court had the benefit of the deposition of Ms. Bonaparte and also the deposition of Dr. Ziti, who is also a medical doctor and medical coding expert, who confirmed that Ms. Bonaparte did the proper analysis and that her opinions are supported by the general medical coding community and the prevailing literature in that area. Lastly, during the trial, there were some improper remarks. I think any one of these would have been reversible error, but cumulatively, they definitely deprived Alan of a fair trial. First, it occurred with Dr. Shim. Dr. Shim reviewed his medical records, diagnostic films, and testified to his medical opinions based on a review. Plaintiff properly brought up that, well, Dr. Shim, you never actually examined plaintiff, did you? No, I did not. And that was a proper question. But what was not proper was for plaintiff to say, in fact, the authority hired you all the time to perform compulsory medical examination. You were not hired to do one in this case. That was a criticism not of Dr. Shim's opinions, but was a criticism of Helen's handling of his litigation. There are many reasons and many different devices discovery that a litigant utilized. And a litigant's decision to employ one form of discovery versus another shouldn't be criticized to the jury.
Was there a motion to eliminate, address that issue, or it came up during trial?
That came up during trial. There was not a motion to eliminate.
So if there's a remand, that's probably gonna be the subject of the motion to eliminate.
Yes. But what I'm concerned about, Your Honor, is if this court doesn't issue a ruling on that, there will be no guidance. But as far as I'm aware, that's a novel situation that's come up.
We don't know what the proof would be on remand. That's the problem with asking for too much guidance. Hands are tied by trial if it unfolds.
The other area that occurred with Dr. Shim was plaintiff's statement. Well, plaintiff's treating physicians should be believed over Dr. Shim because plaintiff was trusting her physician to be honest and truthful. That's a comment on the witness's credibility, which parties or their counsel should not be allowed to make. Second, our physicians should be sued for malpractice, where the authorities expert should not. Malpractice has nothing to do with an expert credibility, and the jury was given no instructions about the burden of proof of malpractice, where it would apply and not apply. I believe that was error. Second issue was with Dr. Foley, who was a radiologist. This court has previously held in Milburn versus State that a party shouldn't bring up a party's opposing party's prior retention of next. In this case, during opening statements, Appellee's counsel told the jury, well, and by the way, we hired a radiologist that the authorities hired. And then that also came up on direct during Dr. Foley's testimony. Now, I can see a situation where if we attack Dr. Foley's credibility by saying, counsel isn't true, counsel planned to pay you $1 million over the last 2 years, and on redirect, it might be appropriate to say, well, isn't it true, counsel for defendant has paid you $1 million. But it's improper bolstering when there's no attack on a witness bias or prejudice to just bring up the fact that in the past, the opposing party has hired that expert. It was also inappropriate for Appellee to argue, closing argument that injured people shouldn't have to pay out of pocket for medical bills. That was an attempt to suggest to the jury that Ms. Ford had no insurance. And it was also an appeal to the jury to relieve Ms. Ford of the financial burden of her medical treatment without consideration of fault. This case, Freno versus Resnick, which is cited in the brief, says the subject feelings were blatantly prejudicial. And lastly, during closing arguments, trial counsel for appellant made a comment on the evidence. There was photographs of Ms. Ford doing some gymnastics. And counsel remarked, look at these photographs and then look at the medical records. Medical records indicate that plaintiff has an obesity problem. That's not reflected in these photographs that were presented to you as being representative of a pre-accident condition. So it's our position that these are old photographs. In closing arguments and rebuttal, the trial counsel for appellee said, according to the authority, this word is a fat liar. That's an inappropriate comment that was intended to inflame the jury. If this had been a defense verdict and the authorities counsel called Ms. Ford a fat liar during closing arguments, I don't think the court would have had a problem reversing that inflammatory comment. I think it works both ways, especially when counsel for the authority had made no such statement. If there are no questions, that concludes the presentation.
Thing has been interesting. Comments?
No, Catherine Williams,
Okay.
at least what, I do want to confirm, we have agreed that should be amended to the time. Court made the narrow fact in stating that they did not have an engineer.
Well, what is a new trial? All issues, partial issues, what, is there more to the agreement?
New trial on all issues, but we agree. That expert is, I have to concede that
They accept the stipulation.
there was no discussion of the stipulation except what Judge Smith read from our brief. My conclusion is should be removed from the trial.
Why are we here?
The only reason I am here is to point out that defendants PTSA's argument that judgment should have been entered in its favor on sovereign immunity issue should be a non-issue. I want to read one statement that was made by Mr. Jensen during the argument after the trial court reopened evidence to get testimony from the lawyer who sent the letters that issue. Mr. Jensen, I am backing off the legal imposition. The court. So he's, as I understand it, abandoned the legal deficiency of the notice. Is that correct? That is correct, Joe. The only contention here is the manner in which the trial court addressed that would be any surprise or prejudice.
Well, I mean, aren't they arguing that whether or not, the STA received it? I mean, I understand it because deficiency is a little different than the receipt.
Let me point out the statute as read by the trial court. The trial court did make a clear ruling. Mr. Jensen commented earlier, the trial court never made a ruling. It's on page 717 of the transcript. Court finds that the testimony that was presented today is sufficient to show compliance prima facie with the requirement of the statute. Further found no surprise. Statute itself focuses on provision of notice, not receipt by the agent. And that is actually something in 6B. It says these are not elements of cause of action of negligence. And the Florida Supreme Court in 2011 in the economic said this is something that is burden of proof for the defendant. If there is an issue, they have to plead it with specificity and particularity.
So long as the notice has the proper party and the proper address, then it was sufficient that as long as they put it in the mailbox.
And receipt confirmed by certified that return receipt green card, which is what the co-counsel for the plaintiff was called. Yes, this is the letter came from my office. This is my business record. This was sent by my office. Green cards came back to my office. And he also testified that the agency responded. So they received notice. The question of receipt of notice was not an issue, and that was conceded at the trial. So when the statute focuses on notice, not provide any right for jury trial to decide. I mean, some courts resolve technical issues on directed verdict all the time. I mean, of course.
So how are we, so if we reverse remand for a new trial, how do we grapple with the issues that have been raised on the appeal that Ms. Ward doesn't address when we have cases that say failure to address an issue results in waiver? So
I agree, I have waived that. And I can't go into the reasons why we did that. But we have waived the right to do that.
okay.
I'm not fighting it. The only point I'm fighting on is
The sovereign immunity.
that they should not have judgment entered in their favor on the sovereign immunity issue. Especially when they've already conceded that the notice was sufficient. And the only question, the only dispute is either it comes down to the manner in which the trial court reopened the case to do so, and I said that they did not abuse, the judge did not abuse discretion in doing so. That what he did was necessary to have to see justice done, especially when they conceded that the plea was directed verdict. Trial court did deny directed verdict on the defendant's third affirmative defense. It's an affirmative defense. It was denied. The ruling was made. There is nothing wrong with that. It was resolved for certain. I mean, it's clear and outright in the record. There's no need to have submitted to the jury. And during trial, the defendant never even attempted to argue that it should be in jury instructions or added to a verdict. They just renewed their motion for directed verdict. Close of all evidence that it was denied for the same reason.
So is the issue that stipulated to disposition of the appeal, or does this court need to go further and address the sovereign immunity issue?
I think the issue, if the opinion were to be remanded for new trial, that is all that you need to say. Because what is asked on the sovereign immunity issue, the appellant is asking for an affirmative judgment entered in their favor on the entire case.
But that's a factual dispute. Does that relate to a factual dispute?
I think that's actually an issue of law,
Only a issue of no.
on the sovereign immunity, yes, because they conceded the
Why didn't they
sufficiency.
summary judgment on that?
I.
Are they right?
No, they're not.
Why do you disagree? What was your right reasoning again?
Disagree on what point.
On the
you're making.
remand, sovereign immunity, knocking it out in their favor.
I'm sorry, I'm not
You're
understanding.
saying they want sovereign immunity reversed in their favor.
They want judgment entered in their favor.
And
Defense
you
verdict.
want a trial on sovereign immunity?
I want a new trial on all points. And the sovereign immunity issue is an affirmative defense that would still be in the pleading, that would still need to be resolved. I think by conceding that the notice was legally sufficient, I think that would be a very quick motion that would be resolved before you ever got to trial. And the fact that we now have testimony under oath from during trial confirming that notice was sent from the plaintiff's counsel's office and green card received, I think that's a very quick motion.
Is that a factual dispute? You're saying a factual dispute or a legal dispute?
The question of whether judgment should be entered is.
No, that's the question of whether the notice was received.
Question of whether notice was received is a, but for their agreement during trial that it was received and is sufficient. Actually sent, the statute focuses on it being sent, not received.
And sending is a test, not received.
The notice must be provided.
And just so we're all clear, sending isn't just like putting an envelope and a stamp in the mail. It's certified return receipt,
It was, and the fact of receipt,
which is why the courts don't focus on receipt. Because it can sit at the post office until someone a month later decides to go pick it up.
in this case, co-counsel at trial testified. We sent it and we got the green card back.
Yeah, so isn't that an issue that we have to decide because the issue has been teed up for us to decide and it's somewhat dispositive? If we, find for the appellant, then you're out, right?
If you find for the appellant on the
On the
sovereign
sovereign
immunity
immunity
issue,
issue,
yes, because
right?
they're asking
Yeah,
for
so
judgment
it's
to
a
be entered in
dispositive
their
issue
favor,
that we have to deal with.
which, and that turns on the question of whether the trial court used a correct procedure. Because legal sufficiency was proven and then conceded. So the trial court did not err by reopening the case and taking evidence. He made specific findings that there was no prejudice, no surprise. And then denied directed verdict on the third affirmative defense. I don't know what more the trial court could have done. I mean, he made an explicit ruling that it was, notice was sufficient, and then denied directed verdict.
So it's somewhat of a hybrid. It's use of discretion whether or not the manner in which you reopen the evidence to allow it, and then making the determination then would be de novo. Is that what you're saying?
I would not disagree. but as a matter of law.
Right, and yeah.
By doing it through directed verdict as opposed to sending it to the jury, that is a matter of law because of the statute, the need for strict construction of the statute. It is not something that has to go to the jury. There's no requirement in the statute that it go to the jury. Unless you have further questions. Remand is necessary.
Can you break down for us as far as, on the issue of the sovereign? You also agree that it's a positive issue that we have to decide regardless of whether your stipulation or your agreement remains for new trial.
I agree, absolutely, it's positive. The conduct case, not applicable in this matter, because that is a completely different section of 768-28. It's clear from Sheriff of Orange County versus Bolte, which is cited in the brief, that this is a issue for the jury. Whether or not a litigant complies with pre-suit notice conditions of 768-28 is an issue of fact. And all issues of fact pursuant to the Florida Constitution and the U.S. Constitution require jury determination from both sides requested. The only means of taking that away from the jury during a trial is through directed verdict.
And so just so I understand, because I don't know that I'm quite getting the point, why, what is the issue going to the jury?
The jury,
Because you don't have a disagreement as far as whether the notice would be.
well, the jury,
I don't know what the objection to is. To the notice.
the objection, Your Honor, is simply that the jury is the appropriate finder of fact. And when a motion for directed verdict, such as Alan's motion for directed verdict, is denied, that means the issue goes to the jury.
I know, but I'm not seeing the issue. When you agree on the record that the notice was sufficient.
Yes, we agreed on the record. However, we disagree that it was properly raised at trial to begin with, since there was no witnesses designated, no exhibits designated, and the issue was handled via.
Time just expired, but I'm gonna give you another 30 seconds to finish it.
Thank you, Your Honor. And because the issue was tried via a bench trial, not a jury trial, on both sides of the main jury trial. Thank you for this time.
Thank you. Okay, the full next case, let me just confirm. All right, next case would be Barry Nolan versus Dennis McLean. We got to that in the morning.
Thank you, Your Honor. Thank you, Your Honors. Keith Miller representing SKRE LLC. I'd like to reserve 7 minutes for rebuttal, if I may.
How many?
7.
The rule here is 5 to 5. Max 5.
Yes, sir.
Yeah.
As a brief summary, SKRE petitions the court to revert somewhat Byzantine and ambiguous discovery order entered in the lower court, which fails to take substantive and procedural protections regarding non-parties, regarding potential trade secrets and other confidential information, and therein departs from the exemplary.
What is this order miss?
Seems to me that what your primary concern is documentation that has to be retrieved by the parties. Subject to the court order, that the name
Specifically with the language of the court order, paragraph 1A, B, and C, direct SKRE to go to third parties and retrieve information. And
and under 1A, you see that retrieving.
And that we've already provided, that's not a dispute. What is in dispute is that the language in 1A requires, it directs SKRE to provide to the respondent in writing the names and ownership information for the defendant, SKRE, that's not part of the objection, and the names and ownership information for any entity which the defendant or any of its owners, including Mr. Coletta and Ms. Record, are affiliated.
What's wrong with that?
Because it's requiring us to then ask third parties, being Mr. Coletta and Mr. Eckert, and any other entity, who you affiliate with, and then get that information from those affiliates.
Define the word affiliation.
There was an objection made to that the word affiliation and a number of other words in the discovery request were ambiguous.
Your main argument say for affiliation only. You want that clarified, limited?
There was some.
It is a little bit ambiguous. Affiliation. I mean, I play cards with them, I play golf with them, they own them. I don't know what that means either.
You're hitting exactly on the ambiguity.
So what is it you
And
want
these
us to do?
debates.
What is it you do?
What we're petitioning for is to basically strike from the requirements any reference to any other third party or what is listed here as any entity which the defendant or its owners, John Coletta Roman Network, are affiliated. Therefore, we do. They did in their capacity as representatives area, that's correct. Paraphrasing the contract language, but there's more to that contract language that is a dispute between the parties, and it's not just 5% coming from their
So I
letter.
don't understand what the problem is. Law that are affiliated. The problem, why not create the privilege law that was also in your.
Because the privilege law wouldn't be Aries privilege, it would be a third party's privilege. The information could be privileged. In fact,
If you just put parties down on the law, then the judge can go ahead and inspect and decide whether there's been merit objection.
we've already indicated that we don't have the power to determine what is a third party's trade secret objection. I don't know what any entities, these third party entities, deem. It's not our privilege. We can only do a privilege log on our privilege. I can't do a privilege log for a third party entity. So
Maybe I'm gonna think of this way too simply, but it says to give the names and ownership information, okay, including whether they're affiliated.
yes,
Okay. SKRE as officers, managers, these are managers, if they is what they're called?
Yes.
Right, they're two managers.
there are a few minutes.
Okay. Sitting in their official capacity, the court has asked the company to disclose this information and provide it. Does the company have a duty to go to the officers and say, do you know this information in your official capacity? And if they don't, which, you know, that'll be another question. But that, it doesn't sound like that has even been done, because you're raising this third, as if they're third parties, when a company actually has individuals who run it. And the way that I'm looking at the order, that's who they're supposed to, you know, provide that information. But, and I don't, that's obviously not your argument, but I have another question, because I don't know that we have jurisdiction, and I don't see the irreparable harm here. When you've not responded to, or we don't see where there's a privilege log or it's gone the next step. So I find that the petition is a bit premature, because I don't think there's been that next level given the court the opportunity to determine some of these other issues that you're raising. If you're talking about trade secret, but I don't know what privilege we're even dealing with.
So Your Honor, I believe it's two questions, two comments there. The first one being, isn't it just easy enough that the court is saying, and the respondent has requested information from SKRE itself? Information,
Defendant is, SKRE is the only defendant, and the court says provide the names and ownership information for any entity with which defendant, or any of its owners, including are affiliated, if the defendant, who are the officers, have that information in their official capacity, then they should provide it, it would seem to me.
that's the nature of our response as part of the record. We actually did respond to that. We have provided SKRE's information. We have provided Mr. information in his capacity with SKRE. We provided Mr. Roman's information in his capacity with SKRE. The court then said that's not enough. The court has then said, Miller is
Do you have an order,
SKRE.
do you have an order saying that? Do you have an order saying that?
Yes. It's the order. It's in
Okay, that's
paragraph
fine. I want
1A.
to make sure.
Paragraph 1A directs us. There in explicitly.
Where does
You
it
talking about the
say?
same order on appeal?
Yeah, I'm.
You're right. It sounded like you're talking about the same order we're talking.
This is the multiple ambiguities within paragraph 1A, because it does direct us to provide.
When you say us, you mean defendant, because it only says defendant is to provide.
And the defendant is SKRE.
Correct.
Right, and defendant is directed to provide information that it has, and it goes through a series of dependent clauses with its own information, which we have provided. Information, here's where it gets far afield, where it says that defendant must provide ownership information for any entity for which defendant affiliates.
If it has, and I guess that's where I'm confused, because on record page 231, Mr. Miller, that's you, says if SKRE is in possession of those, we've agreed to provide those.
Yes.
So if you're not in possession and you can't provide what you don't know.
Exactly, that's.
So that I don't see where this order is, we're reading it in a very broad sense and stretching it to provide for third party, because you're probably anticipating what's going to come next, but I don't think that's what the order is.
Correct. Well, I mean, that's the basis of the litigation, and that's the context of the responses, or I'm sorry, the request is to actually have entities for which SKRE affiliates their language. They under their version of reading of the contract are responsible to pay the plaintiff additional monies.
Right, but this order doesn't seem to be reaching out to non-party, like some of the other cases where they direct a third party to provide information. I mean, this seems to me it's only directed to the defendant.
Well, I read 1A saying it is directed at the defendant, clearly, but it is also directed at information that is in possession of Sean Coletta's affiliates.
No, about, I mean, it's a defendant can only provide what they're in possession, custody, and control of, right?
Absolutely.
Okay, so I'm not seeing where this goes beyond.
It is, I read 1A to indicate that the court is directing the SKRE to not only provide what's in its possession. It goes on to indicate that if there's an entity for which SKRE affiliates.
Yeah, but if they know, they may not know. I don't know. That's a different issue, like I said. If the company has business records that they're aware of who the other entities are, the owners, for whatever reason during their practice, then they have that information. So
Your Honor, that's precisely our response in the record, and the court then sanctioned us or
It seems
not.
like we're running stuff premature
Yeah.
because there's no response saying. You have to provide an record saying, look, you got all Here we have nothing, because here's the privilege log that we think we cover some of this. Is the judicial labor finished here, I guess, what I'm getting at.
I think it is when it's regarding SKRE, but, and then after the response was provided to the other side.
Maybe that's what we're missing. Or can you point to something in the record where there was some sort of response or compliance or notice in the record that you complied with the motion to compel and that there's some other order outstanding that we're not aware of?
Well, it's a motion to compel that's on appeal, so.
No. Did, when this order was entered,
Yes.
was there any records responsive to this order submitted and provided?
After the petition was filed.
No, because after the order came out, prior to the petition.
Was filed shortly thereafter.
Okay, so this would be the point, is where's the opportunity for the court to correct? I mean, that's not our job to correct what I think you're asking us to correct. 'Cause on a petition for cert, we can only quash the order. We can't enter direction.
I think perhaps, I should explain it this way. Your honors are hitting on exactly what are the proper vehicles for discovery. They asked of a request, we have a response, there's discussion, they filed a motion to compel, and it went to hearing, the judge issued an order. And that's the order for which I've requested relief on petition for writ of cert.
But you took an appeal before trying to comply with the order.
On the language of the order that I think is out of bounds. So to the extent.
Under whether you feel order is reasonable or what. But you see a lot more into that order.
Well, let me at least have the opportunity to explain what I'm reading into. What I'm reading into it, and I think the language is plainly there, is that it is ordering SKRE to produce what it has, which is under the rules. But it goes beyond that to say that SKRE is directed to grab ownership information of
No, it
people
doesn't
other than
say that.
SKRE.
It says provide the names and ownership information for any entity with which defendant or any of its owners, including Mr. Coletta, Mr. Eckert, are affiliated. Like I said, if the company SKRE has that information, then they're to provide it.
Then I want to back up, because our response describes that we, just by virtue of our response, which indicates it's responding to the various questions, the various interrogatories.
Bill, I'm gonna assume you want 5 minutes, probably.
Yes.
Okay, then you're down to 5.5, and you repeating yourself. So
Sure.
between now and 5 minutes, which is 35 seconds, you can keep going, or you can save that time, whatever you want to do.
Well, I'm doing my
I
best to
think we're
answer.
going in circles. I'm just trying to mediate. Let's move forward to say something different, or sit down and come back and do 5 minute rebuttal.
The point that I want to make on opening then is the particulars that I believe are written into 1.A involve secrets that are trade secrets for not only for in the possession of
There's something you didn't say. Something a broken record. You said that. I think we get it. I'm just trying to save you time. Now you're at 5 minutes, so keep going, or
I'll save my time for later.
okay. All right, now let's move on to someone that has a chance. That's Megan on.
Megan Serrano, yes, that was my name. Thank you. Good morning, Your Honors. May it please the court, Megan Serrano, on behalf of Vincent Plain, to respond. The standard of review of the discovery order is whether the order is perfect in the essential requirements of law, causing material injury to the law. It's responded contention of the force.
Well, let me just ask you, he's saying the order is overly broad. I'm filing an appeal because I don't want to end up with a discovery law and something, whatever his position is overly broad. Do you agree or disagree that the language is overly broad, or is he reading something into it that's not there?
I believe he is reading something into it that is not there. I think the order is extremely narrow. It is much more narrow than what the plaintiff, Mr. McMahon, was requesting that the court do on the
So you, it sounds like you would stipulate to the ones being revised and amended discovery order being issued if necessary, but I get the impression that you were seeking sanctions against him for not complying timely.
We did, and I think I can clear up some confusion here. So the order was, the order of events, I mean, the order of events was that this order was entered. This petition was filed, and subsequent to, not quite sure the timing of the motion for sanctions and petition, but the motion for sanctions was filed, but it's never been heard. So anything addressing the motion for sanctions is at this point premature. Subsequent to this petition.
But the filing alone, that supports your position, that belies what you just said, that you wouldn't be seeking sanctions for trying to, at the same claim the order requires him to reduce something he doesn't have, or it's overly broad.
Except that then the petitioner filed supplemental interrogatory answers and answers to the request for admission, which are not further record. That is the question. And I would note that in those responses, there wasn't. So again, referring to the standard, whether there was a departure from the essential requirements of law, is my position that it was not appropriately provided for protections for any privileged information that could be disclosed in the privilege law. Today, and this discovery was filed more than a year ago, no such privilege.
And what is your position on whether or not we have jurisdiction on irreparable injury?
The court does, of course, have jurisdiction to correct that. The idea being that the case did not proceed to file if this is going to be.
No, but is there irreparable injury here where the court asked, where the court directed that the defendant provide this information and provide privilege law if there was any objection to it? Are we dealing with something that's premature here?
No, you're not. And there is no risk of irreparable injury. There was no chance that trade secrets or other privileged information could be improperly disclosed. Privilege law could be provided for us. The order does not exceed the scope of authorized. Your Honor pointed out, LC only has to its member managers. We know from the preliminary interrogatories that Mr. Coletta and Mr. Ecker are members / managers of the company. So if they have this information, they can just behalf of the company. This is not exceeding.
Okay, so, but if they have the information in their official capacity, correct? And basically, if the company has the information.
Correct, because the company, in this case, an LLC, can only act through its members or managers. And I would like to point out that both rules which I did do in this order already include the requirement that the responding party must make reasonable inquiry of himself, his attorney, his agents, and his employees to provide information. I wanted to address because respondent has the burden to develop the discovery and is on the part of the because there is some objection that were requested to be burdensome. This objection was raised in the Latin trial and the court this objection. So there are many reasons why, and of course, in the trial, the party may want to request the same information from sources. And it also rewards that working things like documents, and by asking for that information, there's of course certification for the party responding to the discovery that the information produced is accurate. The The starting point, of course, for any discovery dispute developments, all the information that the court required to be disclosed in the order is relevant, to the agreement. It's asserted, which of course, as Barry wants tonight. So for all of these reasons, again, we do not believe that the order of question the essential requirements of law, not causing material. Thank you.
I'd like to briefly address just two issues on both, if I may. The first is the issue of sanction. There was a motion for sanction described that's not what's addressed in the brief. It's the sanction that the judge imposed by this order has to do with the fees and the costs associated with bringing it. That's what is the sanction that's referenced in the brief. So there is a later motion for sanction, but that leaves a separate issue. And that sanction is must be based in part because there's been some non-compliance with the original discovery order. We have provided responses in the original discovery order, and by virtue of the fact that the judge is telling you to do more, is why I read paragraph 1A the way I read it. We have responded with SKRE's information. We have responded with the ownership information regarding Mr. Coletta.
But that's still after the petition filed? Is it-
No.
Okay, no,
I'm
I'm sorry. The interrogatory answers and the requested answers, those are things, some of those things were filed after that are not part of the petition.
Well, to specifically answer your question, yes, but that's not what I'm speaking about now.
Okay,
Our responses that we believe were responsive to the requests from SKRE and from the two managing members and their capacity for that SKRE were provided. They then filed a motion to compel, saying precisely that's not enough. We need your affiliates information. We need more than that. And the judge agreed and then sanctioned us in the manner of fees. When we did exactly what all three of your honors described as the normal course of discovery, we did that by virtue of the language that's in the order in front of us that says the plaintiff SKRE needs to do more. I'm sorry, the defendant SKRE needs to do more. And that's the basis for the petition. That's why we are here, and I think that conveys jurisdiction, because if the judge is in fact asking us to get information, documents, information from third parties, we don't have the ability to object on really any basis on their behalf, because they are independent third party affiliates. And Judge Valencia is correct. What's an affiliate? I don't know. But the judge has already told me it's sanctioned me once. Do I have to come to you and say, judges, what should I do?
Let me just answer this one. If we can help you get something in writing, we feel our hands are tied by the standard review, and you'll understand why. Okay? That's not what we're gonna do, but we're gonna chat about it. I feel your frustration, I feel your pain. They're doing their job, you're doing a great job, you're both doing a really wonderful job. And this is what happened in discovery among two eggheads. I mean, you both have different interpretations. Get that, take the gloves off and say, this is what we're talking about. We'll go away.
I appreciate it. That's all we're asking for is review on what we think is outside of what is it follows the normal chronology of normal discovery. And then the judge says we need more. So that's where
You're both overthinking. That's just my humble opinion from the cat side. And you're both great people. I love this, but I don't want to see you suffer self-imposed. And that's what you both doing to each other. So we'll figure it out. We'll help you if we can. If we can't, I make no promises.
Appreciate that. That's all I ask.
All right. So listen, have a nice day. Thank you for coming here. We'll be in recess.
All rise.
Take your time.
Thank you. Travel safely.